On the agenda, the board will discuss its rules and regulations regarding voter registration as it relates to the Help America Vote Act. And the board may vote to commence the process of revising its voter registration regulation. I'd like to call on our counsel to...
Thank you, Mr. Chair. I have, in light of the complaint that was filed over a month ago by Mr. Block, I've had the opportunity to carefully examine our current regulation that we have in place concerning voter registrations. And I believe that in order to remove any ambiguity with respect to the full compliance of our regulation with each of the federal requirements under the Help America Vote Act, it is my recommendation that we commence a revision to our current regulation, that we, one of the focuses will be on the language in the current regulation that basically excludes people who are in-person registrants from being required to provide their driver license or the last 4 digits of their social security number when they actually apply. And it seems to me that based on the language of HAVA, despite some of the countervailing arguments, and those are considerable, it does seem to me that we should begin that process. So if the board agrees with that, I would, over the course of the next month, prepare a regulation for you to consider, as well as to then put out for public comment under the Administrative Procedures Act.
Mr. Chair, if I might, we have been spending a lot of time looking at this information, and it's not an easy question by any stretch of the imagination. I think counsel agrees with that this is something that, I mean, frankly, I'm not sure why this becomes a major issue for us. There are so many things that we've been doing that are improving the voting process and the election process, that this seems to be not one of the more significant issues in terms of trying to make the system work better. Part of what my concern has been, and still is, that as proposed by Mr. Block, the regulation might very well violate the Equal Protection Clause by treating people differently in different categories, which I think is a legitimate concern. I also note that we have spent a great deal of time, and by the way, no backup has ever been given to us by the complainant about this. We've been told that there are attorneys who validate it. We haven't heard from them. We haven't seen any data from other states. We haven't seen any information whatsoever in terms of any support for this by the person who filed the complaint with the Justice Department. So in the absence of absolutely no documentation or backup information that was presented to us at any time, in fact, we found out about this complaint by reading it in the journal, as opposed to having the courtesy to give the board the information concerning any questions that might exist, which raises questions concerning why it was done that way. We have spent a great deal of time and effort looking at other states, which apparently wasn't done before this complaint was filed, to determine how other states handle this and how other states go about this process and what they consider to be appropriate compliance. That's particularly important because a number of states were, prior to a Supreme Court decision a couple of years ago, subject to the pre-clearance requirement by the Department of Justice under the Voting Rights Act. Voting Rights Act, from the time it was adopted in the 60s until just a few years ago, required those states and those counties in those states that had shown patterns of discrimination be required to have the Department of Justice approve any changes to their voting system as a pre-clearance requirement. So certainly when you look at what other states have done, we should look very carefully at ones where the Department of Justice has already said that a certain procedure or a certain process is acceptable based on the pre-clearance requirements that existed. So our staff has done a tremendous amount of work contacting other states in order to figure out what's going on in this and whether we are an outlier or not. And we are not an outlier by any stretch of the imagination. There are alternative ways of doing this that I want us to consider. One of them, and the one that apparently the greatest number of states use, is to process the application, to put the person on the voter registration list, and then simply require that that identification be presented at the polls. Since we already have a voter ID requirement, photo ID requirement at the polls, that would be a minimal disruption in the system, and I think it's an alternative the board should seriously consider. That's been allowed in states including Georgia and Mississippi, where the Justice Department apparently has said that's a perfectly acceptable approach. There are other states that, there are a couple of states that don't accept the application, but that is a distinct minority. Only 4 of the states that we surveyed, out of the 27 responses we got, said the application is not accepted, period. The vast majority of states follow our procedure in terms of registering, but then simply require the photo ID or the social security number at the time of voting. And to me, that shows how, frankly, trivial this issue is in consideration of the entire electoral process. When we have massive hacking of our election systems, when we have issues that we're resolving through post-election audits that we've worked with in cooperation with Common Cause and other individuals, including the Secretary of State, when we have resolved some of these issues through automatic voter registration, the number of individuals that this affects, I am convinced, is minimal. And to require us to reject those applications would put us in the minority of states, the absolute minority of states. And if we want to find a solution, there are other solutions, such as the one about simply requiring them to show that information at the time they vote. The survey that we've done, several states provided direct information in addition to responding to the survey. Mississippi, there's no requirement for an absentee voter who casts his or her ballot by mail to present any type of identification. District of Columbia, the ballot is stamped ID required. Instructions are included how to do that. We already do that with the online federal data. Bob, am I correct? We already require them to submit identification when they've registered through the HAVA process. Is that correct? Right, and we routinely reject ballots where they did not provide that information.
Mail ballots.
Mail ballots. So we already routinely reject mail ballots.
When a HAVA voter requests a mail ballot, Secretary of State, when they enter it into the system, it puts an asterisk on the label. And that flags us to look for the HAVA ID inside the envelope after you certify it.
Right.
If that information isn't there, then we bring the ballot back to you to void.
Right. Wisconsin, for example, which has strong voter identification laws, their process is for in-person registrations prior to Election Day, or at the polls on Election Day, which is required under HAVA. The application would be processed if the applicant does not have a driver's license or social security number. They're assigned a separate number. Prior to Election Day, they have to provide some information around Election Day. So that was by far the most common approach to this, not the draconian all or nothing solution that was included in the Department of Justice complaint that was filed, again, without any documentation or support for how other states might handle it. So I think this board is acting in a responsible and appropriate manner to what I frankly see is an effort to undermine the board. And we are providing all the information. This is going to be a public document, so the public can see this, right? So we're not hiding anything. We are trying to make sure that we help Americans vote, not discourage them from voting. And I think, unfortunately, this regulation may have that impact if we adopt it. So tonight, I'm going to vote to continue the regulatory process because I think we should have a full public hearing on the topic. But I'm still not convinced that this isn't a constitutional violation. And I haven't heard anybody, I haven't heard any of those 6 lawyers that we were told existed say anything to the contrary. So I'm very skeptical of this. I'm very skeptical of the process that was used. I think other agencies and organizations have worked with us. Some choose not to, that's their choice. But I'll note that when this regulation was changed in 2008, Common Cause was present. The League of Women Voters was present. The ACLU was present. Mr. Block wasn't present. And the 3 public agencies that were present had no objection to this. So when people start talking about conspiracies and lawlessness, they are clearly not engaging in what I consider to be responsible rhetoric with respect to the question of the validity of elections in this state. We have worked over the past few years to make this system as transparent and as accountable as possible. And I'm going to continue to do that to the last day of the last minute of my term. So I will vote to continue the regulatory process.
Is that a motion?
Yes, I'm going to move that we continue with the regulatory process and that we have legal counsel prepare a proposed regulation for our consideration.
Is there a second to that motion?
I'll second it.
Question, this process will be subject to the Administrative Procedure Act?
Any regulation that you promulgate will be subject to the APA, yes.
By our choice.
That is by your choice, but it has been consistent now for
Yes.
over 15 years.
Yes.
Is there other discussion on the motion? If not, all those in favor say aye.
Aye.
Any opposed? So ordered.